All right, good morning, everyone. This is the July 27, 2021 meeting of the Charlotte Zoning Board of Adjustment, and is now in session. I am Patrick Welch, the chairman. Also sitting on today's board is Mrs. Deborah Dryden, Mr. Douglas Wilson, Mr. John Floyd, Mr. Raghu Kota, Mr. Marshall Williamson, and Mr. John Floyd. Also present, Shad Spencer, Zoning Administrator, Lisa McCarthy, Planning Project Manager, Terry Hagler-Gray, Senior Assistant City Attorney, Jill Sanchez-Myers, Senior Assistant City Attorney, Max Oliver, Clerk of the Board, and Atkins Court Reporting Verbatim Reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 14th remote meeting of the Charlotte Zoning Board of Adjustments, and I would like to ask for your patience today as we proceed. There may be a slight delay as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial board that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearing on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by North Carolina General Assembly and Sessions Law 2020 that allows for remote meeting and quasi-judicial hearings during declaration of emergencies. Second, each applicant was notified before being placed on today's agenda that this meeting was conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicant and the public in a number of ways. Notice of today's hearings was mailed to the property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there was any objection to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can access today's proceeding. Finally, any individual wishing to participate in today's evidentiary hearing were required to sign up prior to today's proceeding. This information was also included on the board's website. Today's hearing, applicants for the variance for regulation of zoning ordinance. Applicants for the variance for the regulation of zoning ordinance, the order of recommendation agenda would be as follows. The zoning administrator or the zoning staff member will identify the case and recommend approval of the variance with any recommended condition based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then a case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questioned staff, or if there is any reason the board wishes to move the case to regular agenda. The chairperson calls for a motion and second to approve the variance. The chairperson will hold a roll call vote. The order of agenda will be as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant present their testimony for this case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttals. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations. After hearing each regular agenda case, however, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning board staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits will be required to be provided to the clerk no later than 12 on Monday, July 26, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for the purpose of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for any individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearing on zoning and land use matters. All applicants should have been provided with a copy of the advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk the documents were provided to you. If, as a result of this advisory opinion, the applicant would like to request the continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with North Carolina General Statute 160-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board decision by filling out the form, which must be filed with the board's clerk or chairman at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. You will hear 3 cases today, one recommendation agenda item and 2 regular agenda items. Your first case will be case number 2021-053. That's Scott and Sarah Figler, represented by Roy McInwho. Sorry if I mispronounced that. Clerk of the board will read the names of anyone who opposed the case. Will all those who plan to give testimony to today's case be known?
We had one person in opposition to the case. That was Deborah Watt with the HOA of Hayden Hall.
Will all parties to case numbers 2021-053, you will now be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Speak up.
Yes.
That being said, Ms. McCarthy, you may proceed with case 2021-053.
All right, this case is continued from the June meeting because the property changed ownership the day before the June meeting, and the original applicant was not in attendance to represent the case. The new owners are now the applicants, and they are being represented by legal counsel. I'll give you a minute to review the findings, and if you can just let me know when you're ready for me to proceed.
Commissioner McCarthy, you ready to proceed?
Exhibit 1 is a vicinity map of the subject property. Exhibit 2 is a zoning map. The zoning is MX1 mixed use, and it's a conditional zoning district. Exhibit 3 is an aerial map of the property. Exhibit 4 is a close-up aerial map of the property. Exhibit 5 is background. In 2005, the property was subdivided and the single-family home was constructed. In 2016, the applicants obtained a permit for a converted patio addition to the rear of the home that noted the required 30-foot rear yard. There's an ordinance provision that would have permitted an unheated covered patio to encroach 25% into the rear yard, which is 7.5 feet. And staff believes that the permit was issued under the assumption that the addition would not exceed this allowance of 7.5 feet, but it did exceed it since the encroachment was actually 16.6 feet. The applicant stated that the covered patio was enclosed and converted to heated space approximately a year after construction, so any encroachment allowance would no longer be applicable. Exhibit number 6 is the variance request. The applicants recently purchased the home. A survey commissioned for the sale of the home shows that the addition encroaches 16.6 feet into the 30-foot rear yard. The applicants are requesting a 16.6-foot variance from the 30-foot rear yard to bring the existing addition into compliance. And the photos over to the left of the screen are just showing before and after the addition. Exhibit number 7 is considerations. Staff finds that the variance request does not meet all of the criteria within the zoning ordinance for granting a variance. The hardship was not a result of actions taken by the applicants, but were a result of actions taken by the previous owner. The permit for the addition did specify the required 30-foot rear yard. If the variance is granted, it wouldn't alter the essential character of the neighborhood. The addition isn't easily seen because it's on the rear of the property and is bordered by a common open space area. Unnecessary hardships do not result from the application of the ordinance. There's an area within the allowed building footprint on the right rear of the home where an addition could be located, and you can see that to the right of your screen. There's no evidence of practical difficulty or unnecessary hardship. The shape and size of the subject property is consistent with other properties with the surrounding community, and other homes in the area appear compliant with the required rear yard. Exhibit 8 is further considerations. The hardship is not peculiar to the applicant's property. There's an image of the subdivision plat for the property where the common open space area is shown in green. Although there's a common open space area behind the property, it's not unique to the property because most of the exterior lots on Hayden Hall Circle abut the common open space to the rear. There's also a common drive and community park easement in the front of the property, but you can see from the gray shaded areas showing where this easement is located that it's common to other lots in the area. The applicants state that the property is also subject to a sidewalk, landscape, and irrigation easement from the right-of-way to the front of the building wall of the home. That's approximately 44 feet wide and restricts the ability to make additions to that portion of the property. And this is shown on the survey that was submitted with the application. This is a photo of the property on exhibit number 9. And at the end of my presentation, the applicant has also prepared a presentation for you. And there's also opposition to this case, and they have also prepared a presentation.
Could the applicant may proceed with her testimony?
Good morning, members of the board. My name is Sarah Beeson. Along with my colleague Roy Michaud, we are representing Sarah and Scott Flegel today. As Lisa provided you a good overview of the property and the current situation we're at, we can just, sorry, can I advance the slides or do y'all have to do that?
No, it will need to, I'll just advance them if you just say next or give me something.
Okay, next, please. Next again, please. We can do next. Lisa sufficiently provided kind of the property overview. Here's the aerial as previously noted. You can see the subject home and then the area behind it. Sorry, next. As Lisa mentioned, this is MX1 conditional zone for the property. The recorded plats and the applicable ordinance require a 30-foot rear yard. Next. Again, the recorded plats show here the property along with the what is noted as greenway access, but is sent common area to the Hayden Hall Homeowners Association, as well as a cemetery located to the rear. Next. So this is a survey that the current property owners had conducted as part of their due diligence prior to closing on the lot in early June. This is when they first became aware of the encroachment, which Ms. Flegel will go into greater depth later about kind of the timing and how the situation arose. But it shows the greatest encroachment is 16.6 feet at the left, which kind of decreases to 11 feet as you get to the right side of the addition. Next. As Lisa mentioned as well, since the home was constructed in 2005, the prior owner then sought the necessary permits to construct an addition to the rear left of the property. Those were issued. They did note the 30-foot setback and assumed compliance therewith. Our understanding, based on representations from the prior owner, is that this was substantially completed as of March 2017, and then he later modified it to add the exterior casement windows, which is when it was kind of converted and became a heated space. Next. So again, as noted, this is just a survey showing that encroachment that is the base of this request. When the property owners went out to inspect the property and look at it during the marketing period, one of the things you'll notice is there's this possible community fence to the rear of the property, and it is actually enclosed, so it's not apparent upon visible inspection of the property that the addition is as close in proximity to a potential setback as until the survey was revealed. Next. Oh, sorry, can you go back, Lisa? Thank you. And so our understanding based on the scale of the survey is that delta between the community fence to the rear and the actual property line is approximately 17 feet, at least in one location. And so again, it's not readily apparent upon visible inspection when they were looking at the property that there would even potentially be a setback issue because the prior owners had extended the fence all the way to that rear community fence. Next. So just to give you kind of a timeline of how this came about, the Flegels went under contract for the property with a 25-day due diligence period that expired on May 20th. They received the survey the same day, within less than an hour prior to expiration. And that revealed the encroachment. That was the first time that they learned of the encroachment being an issue. Seller would not extend diligence, but agreed to prepare and submit a variance application, which, based on our understanding, it was at least executed and delivered around May 26th. Based on the representation, the variance would be sought and would resolve the issue. They closed on the property on June 16th. They moved into the property on June 18th, and then the initial hearing was held on June 29th. However, seller did not appear at that hearing, and so the board decided to continue it. So next, please. That leads us to a request of reduction of the rear yard by 16 feet 6 inches. Next. We would argue, however, that an unnecessary hardship from the strict application does occur. This structure would have to be essentially demolished in order to comply. And there are a number of mitigating factors showing how this hardship really is not offset by any countervailing hardship to the public or others in the community. Next. We would also argue that it is unique property conditions with the angled rear yard that reduces buildable areas, the entirety of the front yard being subject to easement and encumbered so that you can't make an addition in that area. And so as a result of that, the rear where the addition was constructed is your only buildable area essentially. Next, please. As Lisa mentioned and showed, there's a 44-foot easement from the front building wall all the way to the private right-of-way of Hayden Hall Circle. Survey shows it's 44 feet. In addition to that, encumbering the entirety of the front yard, you also have this community drive and community park easement that was added in 2005 after the initial declarations. And that is common area to the Hayden Hall Homeowners Association. Next, please.
It requires
That's nice. Yeah.
that. Okay.
And so as a result, as you can see here, the house is set back significantly farther from the private right-of-way of Hayden Hall compared to others, not on the B Drive Circle at least. As you can see in this image to the left, the house to the immediate left of theirs is significantly closer from the front setback compared to the Fleagles property, which is set back further and further reducing kind of their buildable areas. Next. When the Fleagles bought the property, it was already constructed with this hardscape at the rear that Simonini had put in the initial construction in 2005. This as well is not an easy removal area, and nor, I guess, would there be the desire to deconstruct that in order to add addition. So we'd argue that effectively that was not available space for an addition. Also shown here is the slant of the property and how it narrows to the left where you were only able to build that property, build that addition, excuse me. Next, please. As Lisa noted, the hardship did not result from any action by the Fleagles. They purchased the property, and simply purchasing with the knowledge that there might be scenarios or circumstances requiring an evidence is not deemed a self-created hardship. They bought the property in its existing configuration and have not changed or made anything else that further exacerbated the encroachment. Next, please. We would also like to note that the addition is not visible to anyone except for their immediately adjacent neighbors to the left and the right. These are from the rear of the property. There's significant vegetation. There's a screen at the rear. Next, please. From the private right-of-way of Hayden Hall, this is the view between those two adjoining houses where the addition is. You can't see back there either. And then the view to the left is from Smithfield Church Road, which is at the rear of the property, and you cannot see the addition from that angle either. Next, please. The property is immediately adjacent to what is noted on all the recorded plats as greenway access. Based on our understanding, when the county accepted several other greenway dedications in association with this community back in 2012, they did not accept this particular dedication. It was later deeded directly to the Hayden Hall HOA, and at this point, it is unused common area under the declaration is our understanding. And so because that area is unused, again, it is not, there's no additional public harm from this addition that's not visible or impeding anyone else who would happen to be behind them. Next, please. Again, this just shows how it wouldn't have been apparent on a visible inspection that the addition was anywhere near a rear property line. Based on just visible evidence, the property fences for many of these neighbors are extended to the rear of this community, possible community fence as noted on the fence on the survey noted below. Again, based on our understanding from others in the area, this fence was in place prior to them purchasing their homes in 2004. So based on our understanding, the fence has been there since 2004. And has ostensibly been enclosed by others. Again, we're not claiming title by any means to this portion of the property or of that rear common area. We're simply using it to note that it is not being used by the common community and that it would not have been readily apparent otherwise to the buyers that this was potentially an issue prior to receiving the survey. Yes, sir.
Cemetery.
Yes, sir. And just to make it clear, based on the photos that you're looking at here, the larger photo to the left, I was standing at the very rear corner where the fence is on the Fleagle side. And so their house would be to the rear of you, and then you're looking to the left, kind of behind the properties along Hayden Hall Circle. The upper right-hand corner photo is from within the property line of the Flegels, looking back at the area between their property line and that fence to the rear. Behind the fence is the remainder of that unused open space area, as well as the cemetery, as you can see there. Next, please. And so as we've kind of noted throughout, in addition to having this buffer, this unused area, there's also the Grace Baptist Church Cemetery directly behind that area. And so as a result of these two areas, especially in conjunction, there's unbuildable essentially permanent open space behind the rear of the property. So the potential for future harm to future home builders is significantly limited, if not non-existent at this point from our understanding. Next, please. And so now we would like to turn to Ms. Flegel, Sarah Flegel, to give her account of kind of how we came to this and some of the factors that weighed in on their decision. And then my colleague, Roy Michaud, will conclude. Hi, Ms. Flegel, will you just introduce yourself to the board and explain why y'all picked this house and purchased it?
Yes, good morning. I'm Sarah Flegel. I'm here today with my husband, Scott. We are both native Charlotteans and have raised our two children here. With both of them attending college in the fall, we decided to put our home on the market in May, where we had lived for 18 years. As you all know, this is an unprecedented time in the housing market, and we knew we would have to act fast. We fell in love with the neighborhood of Hayden Hall and made an offer on the one house that was available.
So when was the first time you learned of did you have any idea of the encroachment, I guess, upon the initial inspection, and when did you first learn about that?
We did not. We learned of the encroachment less than an hour before our due diligence was set to expire when we received the survey. It was the night before our daughter's high school graduation. We pleaded with the owners of the home to extend the due diligence period so that we could seek more comprehensive legal advice, and even offered financial incentives to do so. They were concerned about their upcoming move and not having been able to secure a new home, so we offered for them to live rent-free for an additional week if they would just give us more time to talk to some real estate lawyers. They would not extend the due diligence. Prior to receiving the survey, we did not know of any potential issue with zoning.
So at that point, what led y'all to proceed to closing?
We had just sold our home and there were very few available homes on the market. We did agree to close based on the representation by the seller that they would seek a variance to resolve the encroachment. The prior owner is a home builder and had assured our real estate agent that he had documentation and would pursue a variance. In reliance on his experience in the industry, along with informal legal advice that a variance would resolve the issue, we decided to move forward. We were never told that without a variance, we could have to tear the structure down, only that it could be a problem that we would need to disclose when and if we sold the house in the future.
And so since you've closed on the property and have started to interact with your neighbors, especially the ones directly adjacent to you who are impacted by the addition, do they feel impacted by the addition? Do they have any opinion on the matter?
Both of our neighbors directly to the left and to the right of us have been extremely supportive since we moved in. They've offered to provide background for the neighborhood and have expressed no opposition or complaints there with the addition at all.
Mr. Chairman, I think probably you want to hear from the POA before we close. I assume that's the procedure you'd want to take. And I have a few questions for her. Did they not get that?
Ms. Deborah? We can't hear you.
Can you mute me? Oh, there you go. Okay, thank you. I'm representing, let me turn my other speaker off. Can you hear me?
Yes, ma'am, we can hear you.
Okay. I'm representing Hayden Hall, the president of the HOA board. Hayden Hall is a community of 130 homes. Am I echoing back to everybody?
No, ma'am.
No. Okay. The homes are built on 0 lot lines with 3 different lot sizes offered in the community. The setbacks between homes are 3 feet, with the exception of the 100-foot lot setback at 5 feet. There are few exceptions to the 5-foot setback, but the builders did get a variance due to the lot topography, but none are less than 3 feet. In addition to side setbacks, there is also a 30-foot rear yard setback with a 13-foot tree buffer that is applicable to the lot in question. The home configuration for the 130 homes is 70 60-foot lots, which this home is built on one of those lots, 32 80-foot lot homes, and 28 100-foot lot homes. So the neighborhood is very compressed, and the average home size is approximately 4,200 square feet. There are 36 homes that back up to Hayden Hall common area spaces that we're talking about in this presentation, and 17 that back up to county-owned space. The HOA is planning to have the common area spaces surrounding the edges of the neighborhood surveyed to facilitate analysis to determine highest and best use. We are actually investigating what to do with the greenway that was dedicated and not accepted and given back to the HOA, which borders this property. This includes the land originally intended for greenway access. The HOA concern is this zoning variance will open the neighborhood up to having the other 62 homes applying for the same variance. The neighborhood never intended to have homes cover the entire lot. This presents maintenance, including drainage issues, privacy, and aesthetic issues to our community. We do not want to set this precedent in our neighborhood. As you can see, the neighborhood is tightly packed homes. All of the homes on this street in question are on 60-foot lots and have small backyards. The second slide shows the home as it was built on the lot before the addition. This is a 3,754 square foot structure on a lot size of 9,104 square feet, which is a 60-foot lot frontage. The subject home is placed towards the back of the lot because it has an easement to share the front part of the lot with neighboring homeowners, so they may have access to their homes. That property is part of this property lot. The third slide shows the home built on the lot after the former owner made this addition. The orange highlight is the addition. Again, we do not want to set the precedent in Hayden Hall that a homeowner can build a structure that does not meet the community covenants and restrictions or the city county requirements. And I'm going to stop there. We really do not want to impose a hardship on this new owner to have to tear this property down. But we also don't want to set a precedent in a neighborhood that everybody can go out and build these kind of structures on the back of their home. It does affect the aesthetics of the neighborhood. And I'll just leave it at that.
Now they,
Huh?
now they.
Okay, Mr. Chairman, this is Roy Michaud. I have a couple of questions, if that would be appropriate.
Sure, go ahead, sir.
I didn't want to usurp any member of the panel having questions, but Ms. Watt, it is true, and the POA understands that a person who creates a variance is not eligible to ask for a variance to allow that violation. Do you all understand that?
What will prevent another homeowner in our neighborhood to ask for the same variance, using this house as an example?
Yes, but the person who creates it is not entitled to ask for a variance. Do you all understand that? In other words, if the property owner next door did the same thing, he would not be eligible to ask for a variance, would he? Because he's the one that created it. I mean, you all understand that.
What if Simonini did it, the original builder?
I'm sorry, I didn't understand the question.
What if Simonini had done
What
it
if
back in 2005?
Simonini did it, the original builder?
If he had done it as the original builder? Well, that's not what we're faced with here, though, is it? As I understand it, the POA is concerned that other people might do the same thing and then ask for a variance. Isn't that the concern?
The concern is both that they would do it and then ask for a variance, or discover it and ask for a variance before they do it.
Before they do it.
We do not want people to add to the back of their properties. The neighborhood was never intended that way. And
Right.
you state that the cemetery land may never be used, but that's not an accurate statement. It could be used.
Well, I'll come to that in just a minute, but it is true that any addition that is made by any homeowner after today has to be approved by the Architectural Control Committee, doesn't it? But you
Even
all have
before
to
today,
approve that.
every person in our neighborhood has, even if a removal of a tree or any change to their lot has to be approved by the Architectural Committee.
And so any changes that occurred would have to be, the plans would have to be approved by the Architectural Control Committee, wouldn't it?
That is correct.
And let's assume, and you also have ready access to walk around behind these houses and see what's going on, don't you? I mean, you've got a greenway.
Not his house without going into the neighbor's yards.
I'm sorry, I didn't understand.
Not without the neighbor's
You
yard.
can't see the structure without going into the neighbor's yards. You can see part of the house when you're coming down Hayden Hall Circle, Smithfield Church Road.
But you can walk down the greenway behind these lots and see mostly about what's going on, can't you? Just like the pictures show here. It's wooded.
So if you're stating that we should have walked back there before this came up,
No, I'm not saying you should have. I'm just saying you could.
there are issues with the previous homeowner that prevented us from doing that. And it was a safety issue that even the landscapers no longer worked in this yard. Even though they paid dues, the landscapers stopped all work in this yard and would only do it with law enforcement present at the time.
Well,
It was a
I think
significant
that's the
safety
point,
issue
but
with this homeowner.
my point is that the homeowner today has to apply for architectural approval, doesn't it?
And this homeowner did that.
Yes, I understand.
He did
And
not build what he said he was gonna build.
that's correct, and I understand that. And so with regard to future construction, you could control just by looking at what's going on and ask for a survey if you thought there was a violation, couldn't you?
That's what the architectural committee does. That's what the city permits do.
But if you felt that somebody was failing to honor their commitments under their architectural control approval, you could ask for a survey, couldn't you?
We would not normally ask for a survey. That's up to the city and county permits that this person obtained to build this structure. And we definitely never approved for it to be enclosed and heated.
I understand that, and I'm not quarreling with that, Ms. Watt, but my point is that if you feel that there's some violation in the future, the Architectural Control Committee could step in and make them comply, couldn't they?
That's true if we know they violated.
Right, okay.
And this is a violation of the architectural committee. They did not follow what they were supposed to do. Unfortunately, due to the homeowner, inspections were very limited because we did have to have law enforcement present whenever you went near his property.
I understand. And but the greenway area behind these homes is heavily wooded, isn't it?
It is heavily wooded,
It is heavily wooded.
but it's not heavily wooded. It's not like I live to a heavily wooded area behind my home. It's not heavily wooded.
Okay, and then there is a cemetery right behind it. Do you have any idea of how long that cemetery's been there?
It's been there for a very long time.
And that's not owned by the HOA, is it?
It is not.
Okay. Are you aware that there are any plans anywhere to change the cemetery?
Not at this time, which is one of the reasons why we want to have a survey done of the common areas and the greenway that we dedicated and got back to determine the highest and best use of that property.
Okay, you're talking about the highest and best use of the cemetery.
No, of the common area
Of the common area.
space
Okay.
and the greenway that circles around Hayden Hall. It circles around about 20 or 30 homes in Hayden Hall.
And with regard to, and I appreciate your candor about this. You've indicated that the POA really doesn't want the structure torn down. What would you like to see done?
We don't know what the answer is to avoid the precedent to have other homeowners apply for this.
Okay. Good. I don't have any further questions, Mr. Chairman.
Okay, thank you, sir. Before we allow the board to make any, ask any question, I want to announce that Mr. Marshall Williamson has recused himself from this case, so he will not be participating in this case. But does any other board members have any questions for either the applicant or Mrs. Watts?
This is John Floyd. I have a question for, I guess, the applicant and staff. It seems to me like there's agreement, if we look at kind of the 4 factors we have to consider to grant a variance, it seems like there's agreement that the hardship does not result from actions taken by the applicant. it seems like there's agreement that the variance is consistent with the spirit, purpose, and intent of the zoning ordinance. Excuse me, I'm at home and someone just rang my doorbell and my dogs are going crazy. It seems like there is that the applicant would take the position that having to tear down the structure would create an unnecessary hardship. And the question that I've got is, what is the position on the factor that the hardship does not result from conditions peculiar to the property? I think that's the one issue where I'm struggling. Thank you.
Staff's position on this is that the greenway is shared on the rear of lots in the neighborhood. And also the community access easement is shared by many lots in the neighborhood in the front of the lot. The applicant did state that there was an irrigation easement that's 44 feet in the front of the property. But staff's opinion is that it's not, that there's no peculiar hardships with the property.
Lisa, would you mind reverting to the slide that you showed of the other properties with the common community drive and parkway easement?
Is that it?
Thank you. So I think in addition to us differentiating by saying, it's further mitigated because we have the cemetery, because we have this larger portion of the greenway access, which is, as you can tell behind most of those other lots, including the ones that also are subject to a similar community drive and parkway access, it's a much narrower spot of land. So there's a larger buffer between, again, this is as a mitigating factor. As directly related to the circumstances on the property, if you look at those other properties to the right, where they are similarly subject to that community park and driveway easement, that arc, most of those, as you can tell, have a narrow tail where that wasn't really buildable area for those properties regardless. The lot 6, the one in the stars, which is the subject property here, it could have had more buildable area there, but for that community park and driveway easement, as well as that irrigation easement for the 44 feet from front of the spring wall to the right of way. So we would argue that's how we would differentiate from those others. The others, especially like lot 16 and 15 and to a lesser degree 17, admittedly, that is not really restricting their buildable area where that is based on kind of how their entrance is located.
Ma'am, our court reporter's having a hard time understanding what you're saying.
Okay.
So can you slow it down a little bit?
Yes, sir. I apologize.
Thank you.
Do I need to restate that or are we fine?
Yes, ma'am.
Okay. I'll try it slower this time. Sorry, I apologize. So I would argue that we would differentiate the similar lots that in that they also are subject to a community park and driveway easement as noted by this kind of these semicircle shaded areas. If you look at lot 16, 15, for example, even 17 and 14, all of their front yards and property lines are angles. And so their building area, we would argue, is not similarly impacted by that easement because there's no real buildable area on the front of those, especially 16 and 15. And so if you look at lot 6 to the left, subject property, that is a more uniform lot at the front where it could have had a buildable area. But due to the easement encumbering that front yard, it is rendered unbuildable except for the rear of the property. In addition, as previously noted, at the time of purchase, the existing hardscape improvements, which are substantial, were already there and further limited the ability to do anything addition-wise, except for to that rear yard to the left where the addition was put in.
And do you have any support for the concept that the existence of an easement is the type of peculiar factor that can be considered when assessing whether or not the applicant meets that requirement?
Mr. Floyd, I was going to address that in the closing argument. What you have here is a very unique situation in that behind this property, there is a greenway that is heavily wooded. There is a fence that's 17 feet off of the back right-hand corner of this lot. It's heavily wooded, and behind that fence is a cemetery that's open space and has been for years and will clearly continue to be open space for the future. I don't know whether you've had any experience in moving a cemetery, but it's outrageously expensive.
Yes, got the easement.
And so that is a condition that I think creates a real visibility impact that people will never really see this addition, just like they haven't the last 4 years. And that's a unique situation for this particular lot and probably the two lots next door, but for the very same reason. You don't have the cemetery down there, lots 9, 10, 11, 12, 13. That's a whole different ballgame. And so it is a condition that is very unique to this property. And it would be a real hardship to cause this structure to be demolished. There's no objection from any of the adjoining property owners. They've been very helpful. And you've got a couple who have purchased this property and have actually been caught because somebody else failed to follow the rules. And we don't, I mean, there's no question about that. I mean, and to the homeowner association's credit, they approved this with the understanding that the setbacks would be honored. And I fully appreciate that. So we've all been caught by somebody who just ignored the rules and got by with it for 4 years. And I think that the safeguards are in place where this will not happen in the future. And the homeowners association has full control through their architectural review and just a little bit of oversight. I mean, we're not asking for them to be surveyors, but when you weigh and balance the equities in this, it heavily favors the granting of this variance.
Mr. Floyd, I think in response to your question on the easement, yes, if there's a 50-foot utility easement or anything else that restricts the buildable area, my understanding is that has been used in prior cases to determine whether a hardship or major condition to the property exists.
Does staff have any position on that?
About the cemetery specifically?
No, I'm thinking more about the easement in the front of the yard, whether or not that is sufficient to, make the property peculiar as required under the zoning ordinance.
I would think that's a common condition. People have irrigation systems in their yard. The common drive and community park easement, it is shared. There's not the top subdivision plat shown, but it's also on many lots in other parts of the neighborhood. There's other kind of rectangular lots like 15. So that wouldn't be something peculiar, due to the smaller size of the lots and the more compact development. These hardships are shared by all the lots in the neighborhood.
Thank you. That's all the questions I have.
Okay.
That is, if I could state something, that is correct about the circular easements. I have one in front of my house. There are at least 7 in the neighborhood.
Okay, I want to make an announcement. We've lost one of our members. Mr. Raghu Kota has fallen off. So we now have a 4-member quorum. Ms. Sanchez, is that sufficient or is something we need to continue to next month's meeting?
So because we have a quorum of 4 members and the board can still vote to approve or deny by 3 votes. So there are still enough members to proceed on the vote. If all persons are in agreement with, I have no objection to that. Or
Okay, we will continue on.
Mr. Chairman, there is a question in the chat from Marshall Williams. I don't know if we addressed that or not. It just popped up. Marshall Williamson, excuse me.
Mr.
Hey,
Williams,
this is Marshall Williamson. Since I've recused myself, I'm not sure if I can ask a question or not.
no, sir, you cannot.
Okay.
Are there any other questions from the board or the applicant or Mrs. Watts? I would like to ask the applicant, are you guys okay with proceeding with the 4-member quorum? Or would you like this to be, continue to next month's meeting?
Chairman, we're fine proceeding with the 4-member board. And I guess just let us know when we can present the closing.
Well, I'm through. I don't have anything.
Oh, no. Never mind. We're completed at this time.
Mrs. Watts, do you have any final words?
No, I do not. Thank you.
If there's no further questions, the board now will go into closed deliberations to discuss the proceedings of this case. Case is now in closed deliberations. Okay, as we discuss this case, would like to pass it around no particular order. Mr. Floyd? Your thoughts?
Yeah, I mean, I'm obviously sympathetic to the applicants here. I mean, this is a tough spot to find yourself in. And as my questions indicated, I mean, to me, on 3 of the issues, I don't see any problem. I mean, tearing this thing down is clearly an unnecessary hardship. It's clearly, the applicants did not do anything themselves to create this problem. And I think, given the fact that no one's going to be able to see this addition and those sorts of things, the spirit of and intent of the ordinance is preserved. I also tend to agree with the applicant's counsel that there are protections in place to prevent kind of the concerns that the HOA have. Not only do they have an architectural review committee, but if someone were to come and request this or request a variance, it would be a different situation, I believe, than what we have here, where you have a new homeowner that is kind of stuck dealing with something. And, you know, if someone went ahead and built this kind of thing and they themselves then came in and sought an ordinance or sought a variance, that would be something that I think we would have to deny based upon the language of the ordinance. The one issue I've got is whether or not this is something that is peculiar to the property. And it seems to me like the existence of that easement on the front is what this kind of turns on. Uh, you know, I wish we had more detail on that and whether or not that's sufficient, but I think at this point, I'm probably inclined to grant the request.
Thank you, Mr. Floyd. Mr. Wilson?
Yes, thank you, Mr. Chairman. Yeah, this is a hard decision as well. I do see where both sides fall, but I just feel like the applicant was put in a position that was not their doing, and it looks like based upon the presentation from both staff and the applicant's counsel, that it appears that the applicant tried to rectify the issue that they were dealt with. So like my colleague, I am leaning to granting this variance.
Good. Thank you, Mr. Wilson. Mr. Dryden?
I too am troubled with this rezoning request. It bothers me that homeowners take the position that I'll build it and then I'll ask for a variance. It seems to me that this homeowner, based on everything I've read, built this patio and within a year decided he was going to enclose it. I don't think you all of a sudden make that decision. So I understand the neighborhood association's concerns. And, you know, even with an HOA or a POA, there's only limited things you can do because of financial resources. This is not the current homeowner's problem. I mean, they didn't create the problem. And with the housing market in Charlotte, I can see why they wanted to move ahead with this, because if you lose it, then you don't have a home to live in. So I will vote to approve this variance. But I, again, want to state that I really am troubled by homeowners who I'm going to build it and ask permission afterwards, that take advantage of our zoning rules to the extent that it causes ripple effects down the road. And I can't see, I understand the neighborhood association's concern about setting precedents, but I don't believe that this necessarily sets a precedent. What it says is, we know that there's a brand new homeowner and that they did not create this, and so we're going to grant this variance. It doesn't say that we're going to grant every single person's variance down the road. That's my position.
Thank you, Mr. Dryden. As Mr. Dryden said, I don't think that this case is going to set that precedence. As my colleagues say, I don't think this is a problem that the current homeowner, you know, created, something they inherited. It's like, unfortunately, we had a previous homeowner that just circumvented the system and built it and then asked for permission. So I am inclined to approve it based off of everything I've heard today. And again, with the HOA, I totally understand. It's not something that you want to see happen throughout the neighborhood. But as my colleagues say, I don't think this is something that will set a precedence for others to do. So at this point, I am inclined to approve the variance. With that being said, I ask for a motion.
This is John Floyd. Motion to approve the variance.
Deborah Dryden, I second.
I have a motion to approve by Mr. Floyd and a second by Ms. Dryden to approve the variance. Send to roll call vote. Mr. Floyd,
Yes.
Mr. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
and yes for myself. Variance has been approved.
Can I say something?
Reading over the facts and findings and condition of law. Do I?
I think we need to change in the conclusions of law, the hardship results from conditions that are peculiar to the property. I don't think that's true. I don't know. I mean,
Are you talking about number 10?
no, I'm talking about, let's see. Yeah, was not a result. No,
Okay.
that's correct.
Okay.
It's number 12. The hardship results from
Number 12.
conditions peculiar to the property.
Okay.
I know that's what Mr. Floyd was trying to get to the bottom of. I don't believe this property, it fits that. Because it's not a condition peculiar to this property. All the properties in this area have the same issue with the buffer and then the common area. That's just my opinion.
So, Mr. Chair, if I may, and to the board members. So in looking at the conclusions of law, all four of the conditions must be present in order to grant the variance. So the board must conclude the unnecessary hardships would result from the strict application. Then the second conclusion of law, the board would have to conclude that the hardship does result from conditions that are peculiar to the property. And then the other ones, as stated herein, would support a variance. But so I think that's sort of a starting place, and then you need to look back at the findings of fact and make sure that the findings of fact are supporting that.
Thank you.
Thank you, Mr. Sanchez. Do we have any recommendation from the board about the facts and findings and conclusion of law?
Yeah, so I think paragraph 15 needs to be restated. Unnecessary hardships will result from application of the ordinance. The numbering is off. It looks like it goes 12, 13, 14, 15, and then starts over again at number 11. I think second paragraph 13, there is evidence of practical difficulty or unnecessary hardship. Paragraph 16, the hardship is peculiar to the applicant's property. And then in the conclusions of law, paragraph 1, unnecessary hardship would result from strict application of the ordinance. In paragraph 2, the hardship does result from conditions that are peculiar to the property.
Thank you, Mr. Floyd, for helping.
Based off the changes, I make a motion, we approve it, the facts and findings and conclusion law based on the changes that were just stated.
Motion to approve the findings of fact and conclusion of law.
Second it, Wilson.
I have a motion by Mr. Floyd to approve the facts and findings and conclusion law and a second by Mr. Wilson. Senator roll call vote. Mr. Floyd?
Yes.
Mr. Wilson?
Wilson, yes.
Mr. Dryden?
Dryden, yes.
And it'd be yes for myself. So facts and findings and conclusion law are approved based on the changes that were stated.
We want to thank you all for your time. This is a tough job y'all have. And we appreciate your attention. Thank you.
Thank you, sir. Next case, 2021-062. 6401 was Alex Court.
All right.
Yeah, this is a recommendation agenda item. Ms. McCarty, you may proceed.
Okay, this is a 10-foot variance request from the required rear yard for an existing addition to a principal structure, and I'll give you a minute to look over your findings.
Ms. McCarty, you may proceed.
Exhibit number 1 is vicinity map of the subject property. Exhibit number 2 is a zoning map. The zoning is R3 single family. Exhibit number 3 is an aerial map of the property. You can see that the property is a corner lot. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The home on the property was constructed in 1985, and the applicants state they received a copy of the 1986 survey when they purchased the home in 1991. The required 45-foot rear yard wasn't shown on this survey. Exhibit number 6 is the variance request. The applicants added a rear addition to the home in 1997. The applicants now wish to sell the property, and a survey showed that the rear of the home encroaches 10 feet into the 45-foot required rear yard. The applicants are requesting a 10-foot variance for compliance of the existing encroachment. Slide 7 is considerations. Staff supports the requested variance. The hardship was not a result of actions taken by the applicants. The applicants state that they were unaware of the 45-foot rear yard. The hardship results from conditions that are peculiar to the property. On the right of the screen, you can see that the lot depth ranges from 115 to 125 feet, and that's smaller than many of the surrounding lots that are 145 to 175 feet in depth. Also, the front setback is 35 feet per the recorded plat, and that's 5 feet greater than the standard R3 setback. It narrows the permitted building depth. Unnecessary hardships result from the strict application of the ordinance and the reduced building footprint to place an addition. The variance won't change the essential character of the neighborhood since the encroachment has existed for 24 years and is not easy to detect. So on the left lower screen, you can see the addition area. Exhibit number 8 is a photo of the front of the property, and that's the end of my presentation. And let me know if you have any questions for me.
No one has signed up to speak in opposition to this case.
Are there any questions for staff from the board? Mr. Murray, are you on the call?
Yes, I am.
Were you wanting to say anything, Mr. Murray?
Since this is on the recommendation agenda and there's no opposition, typically I do not speak.
Thank you, Mr. Murray.
Thank you.
Since there's no question from the staff, I will ask for a motion.
Motion to approve the variance.
One second, Mr. Chairman. I don't know. I see the applicant on the line. I don't know if the applicant has something to say.
Mr. Wilson, he's just on just in case. If
Okay.
someone had shown up in opposition, I always have my property owner on to testify.
Gotcha.
Thank you.
Okay, cool. You're welcome. Sorry about that, Mr. Chairman. I just wanted to make sure.
Thank you, Mr. Wilson. Did I receive a motion on this case?
Motion to approve the variance.
I have a motion by Mr. Floyd to approve and a second by Ms. Dryden. We'll send it to a roll call vote. Mr. Floyd,
Yes.
Mrs. Dryden,
Dryden, yes.
Mr. Williamson,
Williamson, yes.
Mr. Wilson,
Wilson, yes.
and a yes for myself. The variance has passed. Viewing the facts and findings and conclusion of law.
Mr. Chair, I don't want to step on our council's shoes. I just wanted to make sure, since we've only got 4 members of the panel, do we need to get confirmation from the applicant that they are fine proceeding, which I assume they don't have any objection to at this point?
No, actually, we have 5. Mr. Wilson was back on this case. He just recused himself from the previous case.
Okay.
Make a motion to accept the finding of facts and conclusions of law as written.
I have a motion by Mr. Dryden to accept the facts and finding conclusions of law.
Seconded.
I have a second by Mr. Floyd. Send it to a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Mr. Williamson,
Williamson, yes.
Mr. Wilson,
Wilson, yes.
and a yes for myself. Facts and finding conclusion of the law has been approved. Moving on to our next case, case 2021-056, 3630 Craig Avenue. This is a regular agenda item case.
The next case is a request for a 6-foot variance from the required rear yard for an existing addition to a principal structure. And I'll give you a minute to look over your findings.
Mr. McCarty, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R4 single family. Exhibit number 3 is an aerial map of the property. And exhibit 4 is a close-up aerial map of the property. Exhibit number 5 is background. The home on the property was constructed in 1971. In 2006, the previous owner added a master bedroom addition on the rear of the home, and the permit noted the required 40-foot rear yard. Exhibit number 6 is the variance request. The applicant now wishes to sell the home, and a survey revealed that the master bedroom addition encroaches 5.5 feet into the required 40-foot rear yard. The applicant is requesting a 6-foot variance to bring the existing master bedroom addition into compliance. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship wasn't a result of actions taken by the applicant because they purchased the home in 2019 after the master bedroom addition was constructed. The applicant stated he was unaware of the encroachment. The hardship results from conditions that are peculiar to the property. You can see on the graphic on the middle of the screen that the rear property line is angled and the lot narrows in the back, and that creates a smaller and irregularly shaped building footprint. Also, the recorded plat for the property to the right shows the 40-foot setback imposed on the property by plat, and that's 10-foot greater than the standard 30-foot setback for the R4 zoning district. So that also narrows the allowed building permit depth. Unnecessary hardship results from strict application of the ordinance, and the requested variance will not alter the character of the neighborhood. The encroachment is not easy to detect, and the footprint of the home will remain the same as it has been for 15 years. Exhibit number 8 is a photo of the front of the property. And that's the end of my presentation. You can let me know if you have any questions. And also the applicant is here and has also prepared a presentation. And staff has received opposition for this case.
Okay, may I have the applicant?
Yes, good morning, board.
We have one person here in opposition, Dana Childs.
Okay, may I have the applicant and Ms. Childs?
Yes. I'm here.
Yes.
I need to go ahead and swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
I do.
Okay, applicant, you may proceed with your presentation.
Yes, I believe Ms. McCarter covered most of it, but wanted to highlight here on the survey the part of the property or the structure in question. As she highlighted, I purchased the property in October of 2019. Understood that there was an addition to the existing home, asked to see the permits, and those were provided. So was under no knowledge that there was a setback violation at the time of purchase. I've since been relocated for work and looking to sell the home, and a survey revealed the issue. You can go to the next slide, please. So this is just pictures of the property with the corner in question. Wanted to highlight that structure. But again, as she highlighted as well, the construction matches the approved and permitted build plan, but because of the unnatural rear lot line, the northwest corner of the addition extends 5.5 feet over that 40-foot setback line. You can go to the next slide, please. Ms. Child's property line here, I just wanted to highlight and circle the property line in question. I don't have anything else other than to just highlight this is the property line that we are discussing with the opposition. So, and then I think I had one more slide of another neighbor that voiced some concern about a fence deteriorating. I spoke with Mr. Heidrich once he logged his opposition and discussed and showed pictures of his fence at a number of points where it was deteriorating, but I probably not applicable anymore since he's not on the line and I believe is withdrawn opposition. And that is all I have.
Does staff or board has any questions of the applicant? Ms. Childs?
Yes. I really just had a question about how it would impact potentially if I sell to a developer or decide to how his approved variance would impact my setbacks or if they would at all.
It should not impact your setbacks at all. It's completely contained on his property.
Okay, that was really my big question. That was it.
Thank you, Ms. Childs. If there are no further questions from the staff or board, we will now go into closed deliberation to discuss the case. Okay, now Case is now in closed deliberations. Now to the board, no particular order. Mr. Wilson.
Thank you, Mr. Chairman. After hearing staff's recommendation and also looking at the homeowner's presentation, I am inclined to go ahead and approve this variance.
Thank you, Mr. Wilson. Mr. Dryden?
I don't have any questions. This was built a long time ago, so I will approve the variance.
Thank you, Mr. Dryden. Mr. Floyd?
Yeah, not a lot to say here. I mean, I think this meets the factors that we're supposed to consider. It's clearly not something that the homeowner or the applicant created. There is an issue with the lot that makes this peculiar. I think similar to the first case we heard today. I mean, it's, you know, they would have to be, I think, required to tear this down. And it seems like, which would create a pretty significant hardship. And I think allowing this, it's a small variance, is consistent with the character of the neighborhood and this purpose and intent of the zoning ordinance. So I would vote to approve.
Thank you, Mr. Floyd. Mr. Williamson?
Mr. Floyd makes all very good points. I agree with him and would vote to approve.
Thank you, Mr. Wilson. And I agree with my colleagues that this is not a hardship that was caused by our applicant. And I am in agreement to approve the variance as requested. With all the board members speaking, I now ask for a motion.
John Floyd, motion to approve the variance.
I have a motion by Mr. Floyd to approve the variance.
Second by Wilson.
And have a second by Mr. Wilson to approve. Senator roll call vote. Mr. Floyd?
Floyd, yes.
Mr. Wilson?
Wilson, yes.
Mrs. Dryden?
Dryden, yes.
Mr. Wilson?
Williamson, yes.
And it'll be yes for myself. Variance has been approved. Reviewing the facts and findings and conclusion of law. Ask for a motion to approve the facts and findings and conclusion of law as written.
I make a motion that we approve the finding, facts, and conclusion of law as written.
I have a motion by Mr. Wilson.
Second by Mr. Floyd.
And I have a second by Mr. Floyd to approve the findings and facts and conclusion law as written. Senator roll call vote. Mr. Wilson?
Williamson, yes.
Mr. Wilson?
Wilson, yes.
Mr. Floyd?
Floyd, yes.
Mrs. Dryden?
Dryden, yes.
And a yes for myself. The findings and facts and conclusion of the law are approved as written. I think that is the conclusion of all of our cases for today. We have the approval of the last month's minutes from the June meeting. Ask for a motion to approve the minutes from the last month's meeting.
I make a motion to approve the minutes from the June meeting. Dryden.
I have a motion by Ms. Dryden to approve the June meeting minutes.
Second here by Wilson.
And have a second by Mr. Wilson. Senator roll call vote. Mrs. Dryden?
Dryden, yes.
Mr. Wilson?
Wilson, yes.
Mr. Floyd?
I was not present at that meeting, so can I vote to approve?
This is Jill Sanchez Myers. You can, if you have reviewed the minutes, and you're confident in the accuracy of the minute taking, then you can vote. You are not prohibited from voting.
Do I have to vote in order for them to be approved, given that we have 4 other members of the board?
No, just 3 votes would be required.
Okay, then I'll abstain.
Williamson, yes.
Mr. Chair, I think you're on mute.
Oh, thank you. The June meeting minutes has been approved.
Mr. Chairman, before we adjourn for the day, just had a question for staff. I know we discussed last month the possibility of going in person again, but with the rise of the Delta variant, has that probably been reconsidered now? Will we still be virtually for August and probably the fall?
All I know so far is that the government center has been open for committee meetings at this time. And right now they're possibly looking, I don't know if it's definitive yet, of opening it back up in September for the general public, but only for the first 2 floors. So right now, what we're doing is just on a case-by-case basis. If the board feels comfortable coming into the government center, then we can have an in-person hearing. If not, then we will continue with the virtual or hybrid type version. So it's just whatever the board chooses to do.
Okay.
Okay, next agenda item is the revision of revision to the rules and the procedures. Are there any questions on the revisions?
Mr. Chair, if I may.
Yes, ma'am.
There is one just typo under Article 9, decisions, under subsection D, public records of decisions. And it's actually was contained in our current rules of procedure and just kind of carried over to the revision. So I wanted to just go ahead and make that typo noted, where it says the decisions of the board, it should be as recorded in the minutes, I believe, not a recorded in the minutes. And I also wanted to just point out that there was a title that needs to be, we need to come up with a title under continuances, that new section. If anyone has any ideas or suggestions. It's under number 3. Where are you? Sorry, under Article 6, meetings, Section G, continuances, and then there was a new, maybe it's only number 2. Oh, I'm missing a page. Sorry. I'm missing page 6. I apologize. I think it's on page 7, number 3.
Oh, we put title, okay.
What if you move the first paragraph of that section 3 up to section 1 and then call section 3 like other grounds for continuance or something like that? Or grounds for continuance?
I'd rather use the word additional grounds for continuance if if that's what you're gonna go with.
Are there any other? Okay, there's nothing further. Okay, then there's nothing further, no other pressing issues from the staff. We'll go ahead and adjourn this month's meeting. Just for the boards, oh, go ahead.
Sorry, Mr. Chair. The board needs to go ahead and take a vote on whether to adopt the revised rules of procedure with the amendments that were suggested today. Thanks.
Okay, we'll go ahead and make a motion that we approve the rules and regulations with the changes that were made today.
Motion to approve subject to the proposed amendments.
I have a motion by Mr. Floyd to approve.
Williamson, second.
I have a second by Mr. Williamson. Send to roll call vote. Mr. Floyd,
Yes.
Mr. Williamson,
Yes.
Mr. Wilson,
Yes.
Mr. Dryden,
Dryden, yes.
and it'd be yes for myself. So the rules are approved with pending the changes that were laid out today. Were there anything else? Thank you. Well, again, as before I adjourn today, I just want to thank the board. As I mentioned to the rest of this will be my last meeting with the board. I've been called to active duty, so I'll have to report on October. So this will be my last board meeting with you guys, and I want to thank you guys for making this, being patient and making this, fun, exciting adventure. So again, it's been great. Thank you guys, and hopefully see you. Guess when I get back.
And
Thank
thank
you
you,
for your
Mr. Chairman,
service.
for your service. Yes, thank you.
Thank you, Mr. Wilson.
Yes.
Thank you, Mr. Floyd. Other than that, this meeting is now adjourned. Thank you, guys. Have a wonderful week. Be safe.
Thanks, everybody.
Thank you.